Great, we have time for just one more question. And it's very topical, to do with social media evidence. It says, many of my judges do not understand technology. How do you propose explaining social media evidence? How Snapchat versus Twitter versus Facebook versus instant messaging works, etc., or the meaning of an IP address, or the meaning of emotions?
You have to tell us. It's like any other, anything else that you want me to know, you're going to have to tell me. If you don't think the judge understands it, maybe you put on an expert. Maybe you find someone, for example, who teaches in the communication department of your local college, or who teaches a class on how to use how social media works. And I suspect that at almost any undergraduate college in America, you can find someone who teaches a course on that. Maybe that's one way of doing it. Maybe you and the other party or the other lawyer can stipulate to what amounts to an instruction manual for the judge as a piece of evidence. There's Snapchat here. I know how that works because my granddaughter Ella taught me how to use that. This is how an Instagram works. This is what an IP address means. Because a lot of those things are not really issues that are debatable. They're a little hard to get a judge to take judicial notice of, I think, but I think that the actual workings of how those social media systems exist and are created is not really up for any kind of scientific debate.
And recall that many of your judges won't have a Facebook account. They won't be following on Twitter.
I've never looked at a Facebook page except as has been presented to me as a piece of evidence in a courtroom.
Because of the ethical issues that are involved with judges being on those things. So as a result, you have to be able to not only understand how you're going to get in that piece of evidence via the rules of evidence, but explain why it's important for the judge to understand it. Why is it relevant? Why is this important?
I want to add one quick thought on that. Generally, what you're going to be introducing is a photocopy of a page, or a screenshot, if you will. You treat it exactly like you treat other pieces of evidence. You've got to authenticate it. It's got to be what it purports to be, which is what's so crazy about emails. We can all manipulate emails anytime we want to, and there can be debates about that. And judges wear the exact same hat they wear regarding any other piece of evidence. They have to decide whether or not there's authenticity. And if they decide there's not, it's not coming in. So take the mystery out of it for your judges by making it simple. Pieces of paper are good for judges. With all due respect, that is good for judges. Pulling up something on a screen live in a courtroom with somebody on the witness stand, that can be good for judges as well. That takes the mystery out of things for judges, and I think that it'll move your case along in a positive way.
And again, talk to your client, because if you have doubts as to whether or not this piece of evidence has been created by your opponent or maybe by someone else, your client's mother, your client's new girlfriend, trust me, the judge is going to have those doubts too. So be very careful that you believe that this very vital piece of information that you want to get in is what it purports to be.